Now, once the emancipation and the Civil War, Emancipation Proclamation, Civil War, once that concluded itself, the pain and suffering and oppression did not go away because it shifted then to a system of apartheid in the sense that the legal statutes, primarily in the southern states, indicated that black folks had no rights, that they should go to the back of the bus, that they should drink from the colored water fountain. So a whole segregated, separate social order was set up by a legal system. So now when you're talking in terms of identifying who's culpable in terms of a legal stipulation, you have to look at the government as one of the culpable parties. You would also have to look at the various businesses that profited from this. And I think that's the angle that is being taken. However, I think the legislative and the political is still an important dimension of it. If you look at the case where it's going now, John Conyers, a congressman from Michigan, has put in place a piece of legislation, a bill rather, which indicates that a committee or a commission should be set up to do an assessment of the damage done to people of African descent from 1619 to 1865. Now, on the heels of that, Randall Robinson had put together what is called a Reparation Assessment Group. And in that group, he has some of the stellar African-American attorneys such as Willie Gary, Johnny Cochran, Charles Ogletree, Attorney Sweets. And so what they're doing now is that they're bringing suit against the government. They're bringing suit against specific corporations, such as Aetna Life Insurance, bringing cases against Brown University, and these various businesses that existed during slavery and made profits from slavery. And so they're approaching it, from that angle. Now, when you look at the approach that Malcolm X, or El-Hajj Malik al-Shabazz took, he was talking about bringing the United States government before the World Court and charging it with the crime of genocide. Now, in order to leverage this, he was trying to get the cooperation of African heads of states in the Middle East and in Islamic countries, and then they would go before the United Nations and the Security Council and make that particular case. And once the case was made, then the United States would be taken to The Hague, where she would be tried in the World Court for crimes against humanity. So you got two legal bases, or two cases that you can make. You can make a case with international law, and then you can make a case with United States case law. So you have two legal venues by which you can prosecute this particular case. Now, however, you're going to need the political apparatus and the mass movement in order to dramatize the issue and bring it to that head and to that climax. The same way Dr. King did it.
It can't reach the court and have the impact that it should without having some kind of broad support from broad political support. Is that what we're saying? Right,
because you never would have gotten the Comprehensive Civil Rights Act, or you never would have gotten the Voting Rights Act had you not dramatized that in society. So I think the political apparatus is important in terms of making the case, and as well as the mass movements, the demonstrations, and so forth. And once the case is made, then the final resting place would be in a court, either a domestic court or a national court inside the United States, as well as the World Court. And then when you bring it into the World Court, not only would you be talking about genocide and the need